Namaskar, Sat Sri Akal, Adab and good afternoon. This is my 134th video and this will cover some very small but GLR, that's the Journal Land Register points. Now, this was a discussion which held with my mentor called Major Chauhan way back in 2008. So, he was trying to explain me in a very random manner that Mr. Das, we need to understand why GLR and how GLR. So where does the rights that have come down, how do we say that they are tampered? They are contrary to my sale deeds of 1919 or prior to the GLR. CLA rules reproduce that the Land Revenue Act of my Punjab 1887, where my rights cannot be tampered or transferred without the permission of the buyer and the seller. So it simply means that in the revenue records or the Jamabandis, there can be no change without, no alteration and additions, without the owner or the seller being a party to it. So that means a patwari or a kanugo or a tahsildar or an MEO cannot make any changes in the GLR. Where is it written? It's written in CLA Rules 3, page 11. Now, even if you see the GLR which was prepared prior to the making of Record of Rights of Ambala 1910, under that government notification of 408 of 1909. It simply said that a general land register was being maintained. Now, the general land register was actually to be maintained under the CLA rules. So, what was that register being maintained which the Record of Rights of Ambala is mentioning? If you read, it doesn't talk of the Cantonment Code, it doesn't talk of the Cantonment Code 1899, it even doesn't talk of the House Property Register. So what were the Cantonment Magistrate at that time maintaining? This is very important. My Cantonment Ambala, I am just talking of myself, came up in 1843. This is the presumption. I presume because the House Property Register and the GG of 1833 mentions Ambala, so I presume Ambala was in existence in 1833. Well, the MEO or the department or the legal officers of the department says Ambala was made in 1843. So this is the travesty. If you read Rule 43, which is in CLA Rules 1937 on page 79, and compare it with that page in the MLM of 1944, 254, you will see how entries in GLR have been usurped, they are purged, they are defunct, they are thoroughly fraud, tampered entries. So column 1 to 13 is totally not acceptable. We should actually be filing a criminal case against the department that the GLR is not being maintained as per the rules. So it is a clear case of abatement of petty officials under the Cantonment Act 283 subpara 2. So why can't we stick on to it? Why can't we people in cantonments file these kind of cases on GLR? Why are we running for filing of public interest litigations in Supreme Court? For what? There is an admission, there is a judgment of Lahore where it says that yes, the GLR is absolutely, evidently fraud. Or I would use the word that it has not been made as per the rules. So there could not be any trust laid on the GLR. So friends, let's make it, let's educate ourselves, let's get our land records, find your estate property sale deeds, None of us are holding 1833 house property register. None of us are holding any kind of these documents under the cantonment code. Does anybody have the 268 register of 1899? No. You will be surprised we do not even have the 1925 GLR in our custody of your and my estate. And believe me, from now onwards, you will not even have the 1937 GLR, full volumes. Bribe, do anything, get it, lay hands, because this will save you in your evidence, and this will prove that why you were subjected to B3, because you were a private land and you were a freehold grant. Once again, I am saying that we were old grants, never converted into new grants because we were not subjected to revenue because of no settlements done within the cantonment. Thank you. Good day.